Election Commission is set up by the President under Article 324 of the Indian Constitution. It is permanent and independent body that directs and controls elections of Parliament, State Legislature, Office of President, Office of Vice President. Election Commission is assisted by Deputy Election Commissioners. They are drawn from civil service and appointed with the tenure system. At the state level, Commission is assisted by Chief Electoral Officer. He is appointed by Chief Election Commissioner with consultation of state government. At district level, Collector acts as a district returning officer. He appoints returning officer for every constituency and presiding officer for every polling booth. Composition of Election Commission. Article 324 made following provisions with regard to the composition. First, it must consist of Election Commissioner and other election commissioners. President may decide numbers time to time. Second, they are appointed by President. Third, when other election commissioner appointed, Chief Election Commissioner act as the chairman. Fourth, President may appoint regional commissioners with consultation of Election Commission. Fifth, service conditions and tenure of election commissioners and regional commissioners determined by President. Chief Election Commissioner and other two election commissioners have equal power. They receive equal salary and allowances and other perquisites similar to judges of Supreme Court. In case of differences in opinion, matter decided by majority. They hold office for 6 years or up to the age of 65 years. Powers and functions of Election Commission. First, determine election constituencies. Second, prepare and revise electoral rolls and register voters. Third, notify dates and schedules of election. Fourth, grant recognition to parties and alert symbols. Fifth, act as a court for settling disputes. Sixth, appoint officers for incurring disputes of electoral arrangements. Seventh, determine code of conduct. Eighth, prepare rosters for publicity. Ninth, advise President on matters related to the disqualifications of members of Parliament. 10th, advise Governor on matters related to the disqualifications of members of State Legislature. 11th, cancel polls in case of rigging, booth capturing, violence and other irregularities. 12th, request President or Governor for requisitioning staff. 13th, supervise machinery to ensure free and fair elections. 14th, advise President elections can be held under President's rule to extend period of emergency after 1 year. 15th, register political parties. Independence of Election Commission. Article 324 made following provisions to ensure independent and impartial functioning of Election Commission. First, Chief Election Commissioner cannot be removed except same grounds as a judge of Supreme Court. Second, service conditions of Chief Election Commissioner cannot be varied. Third, any other election commissioner or a regional commissioner cannot be removed except on recommendation of Chief Election Commissioner. Still some flaws are there. First, Constitution not prescribe qualification of members. Second, Constitution not specified term of members. Third, Constitution not debarred retiring election commissioners from any further appointment. Article 280 of the Indian Constitution provides Finance Commission. It is a quasi-judicial body that is constituted by President every 5th year. Constitution envisages Finance Commission as balancing wheel of fiscal federation. Commission submits its final report to the President. Composition of Finance Commission. It is consists of chairman and 4 other members. They hold office for a period specified by President. Constitution authorizes Parliament to determine qualification and manner of selection of members. Chairman must be a person who is having experience in public affairs. Other members are first, Judge of High Court. Second, person who has knowledge of finance and account of government. Third, a person having experience in financial matters and in administration. Fourth, a person who has special knowledge of economy. Advisory role of the Commission. The recommendations made by Finance Commissions are only advisory in nature. It is nowhere laid down in the Constitution that recommendations shall be binding upon the government. Functions of the Finance Commission. Finance Commission make recommendations to President on following matters. First, distribution of net proceeds of taxes. Second, govern grant in aid. Third, augment consolidated fund of state to supplement panchayats and municipalities on recommendations of State Finance Commission. Fourth, any other matter referred by the President to the Commission. Goods and Services Tax Council, GST Council, Article 279A. 101st Constitutional Amendment Act 2016 introduced this new tax regime. It inserted new Article 279A to the Indian Constitution. That article empowered President to constitute GST Council by an order. Composition of GST Council. It's a joint forum of centre and state and consists of following members. First, Union Finance Minister as a chairman. Second, Union Minister of State in charge of Revenue or Finance. Third, Minister in charge of Finance or Taxation or any other minister nominated by each state government, and they have to choose one amongst themselves to be Vice Chairman of the Council. They can also decide his term. Union Cabinet also decided to include Chairman of Central Board of Excise and Customs (CBEC) as a permanent invitee to all proceedings of the Council, but without right to vote. Working of the GST Council. Decisions are taken at meeting. 1/2 of total number of members is quorum for conducting a meeting. Every decision of the Council is to be taken by majority of not less than 3/4 of the weighted votes of members present and voting at meeting. Decision is taken in accordance with the following principles. First, vote of central government shall have weightage of 1/3 of total votes cast in that meeting. Second, votes of all state government combined shall have weightage of 2/3 of total votes cast in that meeting. Functions of the GST Council. Council is required to make recommendations to centre and states on the following matters. A. Taxes, cesses and surcharges levied by centre, states and local bodies would get merged in GST. B. Goods and services that may be subjected to GST or exempted from GST. C. Model GST laws, principles of levy, appointment of GST levied on supplies in course of interstate trade or commerce, and the principles that govern place of supply. D. Threshold limit of turnover below which goods and services may be exempted from GST. E. Rates including floor rates with bands of GST. F. Any special rate or rates for a specified period to raise additional resources during any natural calamity or disaster. G. Special provisions with respect to states of Arunachal Pradesh, Assam, Tripura, Manipur, Sikkim, Meghalaya, Mizoram, Jammu and Kashmir, Himachal Pradesh, Uttarakhand and Nagaland. H. Any matter related to GST as a council may decide. Union Public Service Commission is an independent constitutional body. Article 315 to Article 323 in Part 14 of the Indian Constitution deals with the Union Public Service Commission. Composition of the Commission. It consists of chairman and other members appointed by President. Constitution doesn't specify the strength of the members. Usually, the members consist of 9 to 11 members. They can serve for 6 years or up to the age of 65 years. President can appoint one of the members as an active chairman in 2 cases. First, when office of chairman falls vacant. Second, the chairman is unable to perform due to absence or some other reason. Removal. President can remove chairman or any other member under following circumstances. First, insolvent. Second, when there is paid employment. Third, infirmity of mind or body. They can also be removed for misbehavior. In that case, the matter referred to the Supreme Court for inquiry. Advice tendered by Supreme Court is binding on the President. Constitution defined misbehavior in that context. Independence of the Union Public Service Commission. First, chairman or a member can be removed only in manner and grounds mentioned in the Constitution. Second, the conditions of service of chairman or a member cannot be varied. Third, expenses, salary, allowances and pensions charged on Consolidated Fund of India. Fourth, chairman or a member on ceasing to hold office of UPSC is not eligible for further employment. Fifth, chairman or a member is not eligible for reappointment to that office. Functions of the Union Public Service Commission. First, it conducts examinations. Second, it assists states in framing and operating schemes for joint recruitment. Third, it serves all or any need of state on request of governor. Fourth, it is consulted on matters related to personal management. UPSC presents its annual report to the President. All cases of non-acceptance must be approved by Appointment Committee of Union Cabinet. Limitations of Commission. Following matters are kept outside jurisdiction of UPSC. First, reservation of appointments or posts. Second, claims of SCs and STs in appointments to services and posts. Third, selections for chairmanship or membership of commissions or tribunals, posts of highest diplomatic nature, and Group C and Group D services. Fourth, with regard to selection for temporary or officiating appointment, President can exclude posts, services, and matters from purview of UPSC. Role of the Union Public Service Commission. Constitution visualizes UPSC to be watchdog of merit system. Classification of services, pay and service conditions, and cadre management, training, and so on are handled by Department of Personnel and Training, not UPSC. National Commission for SCs. Article 338 of the Indian Constitution. It is a constitutional body that is established directly by Article 338 of the Indian Constitution. But other commissions like National Commission for Women 1992, National Commission for Minorities 1993, National Commission for Backward Classes 1993, National Human Rights Commission 1993, National Commission for Protection of Child Rights 2007. These are statutory bodies. They are established by Act of Parliament. Evolution of the Commission. Originally, Article 338 provided appointment of a special officer for SCs and STs to investigate all matters related to constitutional safeguards for SCs and STs and to report President on their working. 89th Constitutional Amendment Act of 2003 bifurcated the National Commission for SCs and STs into two separate bodies. First, National Commission for SCs under Article 338. Second, National Commission for STs under Article 338A. This is how National Commission for SCs came into existence in 2004. Members of the Commission. First, Chairman. Second, Vice Chairman. Three other members. They are appointed by President. Their conditions of service and tenure of the office determined by the President. Functions of the Commission. First, to investigate and monitor constitutional and legal safeguards for SCs and evaluate working. Second, inquire complaints related to the deprivation of rights and safeguards of SCs. Third, participate and advise on socio-economic development of SCs and evaluate progress of development under union or a state. Fourth, present reports to the President annually or whenever required. Fifth, make recommendations for protection, welfare and socio-economic development of SCs. Sixth, discharge other functions as President may decide. Powers of the Commission. The Commission has all powers of a civil court in following matters. First, summoning and enforcing attendance of any person and examining him on oath. Second, requiring discovery and production of any document. Third, receiving evidence and affidavits. Fourth, requisitioning any public record from any court or office. Fifth, issuing summons for examination of witnesses and documents. Sixth, any other matter which President may determine. Central and state governments are required to consult the Commission on all major policy matters affecting SCs. The report of the Commission is submitted to the President. Till 2018, the Commission was required to discharge similar functions with regard to OBC and Anglo-Indian community. It was relieved from this responsibility by 102nd Amendment Act of 2018, and Special Commission for OBC was constituted. Presently, Commission required to discharge the functions related to the Anglo-Indian community. National Commission for STs. It is a constitutional body that established directly by Article 338A of the Indian Constitution. Geographically and culturally, STs are different from the SCs and their problems are also different from those of the SCs. In 1999, a new Ministry of Tribal Affairs was created to provide sharp focus on welfare and development of scheduled tribes. National Commission for SCs and STs was bifurcated through 89th Constitutional Amendment Act of 2003. This act added new Article 338A in the Constitution. The National Commission for STs came into existence in 2004. Members of the Commission: first, Chairman; second, Vice Chairman; three other judges. They are appointed by the President. Their conditions of service and tenure of the office determined by the President. Report is submitted to the President. The Commission acts as a civil court. Powers of the Commission. The Commission has all powers of a civil court in following matters. First, summoning and enforcing attendance of any person and examining him on oath. Second, requiring discovery and production of any document. Third, receiving evidence and affidavits. Fourth, requisitioning any public record from any court or office. Fifth, issuing summons for examination of witnesses and documents. Sixth, any other matter which President may determine. Functions of the Commission. First, investigate and monitor constitutional and legal safeguards for STs and evaluate the working. Second, incur complaints related to deprivation of rights and safeguards of scheduled tribes. Third, participate and advise on socio-economic development of scheduled tribes and evaluate progress of development under union or a state. Fourth, present reports to President annually or whenever required. Fifth, make recommendations for protection, welfare and socio-economic development of STs. Sixth, discharge other functions as President may specify. Other functions of the Commission. In 2005, President specified following other functions. First, measures to be taken over conferring ownership rights in respect of minor forest produce. Second, measures to be taken to safeguard rights of tribal communities over mineral resources, water resources, etc. as per the law. Third, measures to be taken for development of tribals and to work for more viable livelihood strategies. Fourth, measures to be taken to improve efficacy of relief and rehabilitation measures of tribal groups displaced by development projects. Fifth, measures to be taken to prevent alienation of tribal people from land. Sixth, measures to be taken to elicit maximum cooperation and involvement of tribal communities for protecting forests and undertaking social afforestation. Seventh, measures to be taken to ensure full implementation of provisions of Panchayats Extension to Scheduled Areas Act 1996. Eighth, measures to be taken to reduce and ultimately eliminate the practice of shifting cultivation. National Commission for Backward Classes. Article 338B of the Indian Constitution. In Mandal Case Judgment 1992, Supreme Court directed central government to constitute a permanent statutory body to examine the complaints of under-inclusion, over-inclusion and non-inclusion of any class of citizens in the list of backward classes. Accordingly, National Commission for Backward Classes was set up in 1993. Later, 102nd Constitutional Amendment Act 2018 conferred constitutional status on the Commission. For this, amendment inserted new Article 338B to the Constitution. Thus, the Commission became constitutional body. The members of the Commission: first, Chairman; second, Vice Chairman; third, three other members. They are appointed by the President. Their conditions of service and tenure of the office determined by the President. Report is submitted to the President. Functions of the Commission: first, investigate and monitor constitutional and legal safeguards for socially and educationally backward classes and evaluate their working. Second, incur complaints related to deprivation of rights and safeguards of socially and educationally backward classes. Third, participate and advise on socio-economic development of socially and educationally backward classes and evaluate process of development under union or a state. Fourth, present reports to the President annually or whenever required. Fifth, make recommendations for protection, welfare and socio-economic development of socially and educationally backward classes. Sixth, discharge other functions as President may specify. Powers of the Commission. The Commission has all powers of a civil court in following matters. First, summoning and enforcing attendance of any person and examining him on oath. Second, requiring discovery and production of any document. Third, receiving evidence and affidavits. Fourth, requisitioning any public record from any court or office. Fifth, issuing summons for examination of witnesses and documents. Sixth, any other matter which President may determine. Special Officer for Linguistic Minorities. Constitutional Provisions. Originally, Constitution did not make any provisions with regard to the Special Officer for Linguistic Minorities. State Reorganization Commission 1953 made recommendations in this regard. Accordingly, 7th Constitutional Amendment Act of 1956 inserted a new Article 350B in the Part 17 of the Indian Constitution. This article contained following provisions. First, there should be a special officer for linguistic minority. He must be appointed by the President. Second, this special officer investigate all matters related to linguistic minorities. He would report to the President. It must be noted here that Constitution does not specify qualification, tenure, salaries and allowances, service conditions, procedure for removal of officer. Role. Commissioner launched 10-point program to lend fresh impetus to governmental efforts towards the preservation of the language and culture of linguistic minorities. Commissioner for Linguistic Minorities. Special Officer for Linguistic Minorities was created in 1957. The Commissioner has headquarters at Allahabad. There are 3 regional offices. First at Belgaum, Karnataka. Second at Chennai, Tamil Nadu. Third at Kolkata, West Bengal. Each is headed by an Assistant Commissioner. The Commissioner is assisted at headquarters by Deputy Commissioner and Assistant Commissioner. Commissioners falls under the Ministry of Minority Affairs. The report is laid before the President. Functions. First, to investigate all matters of safeguard related to linguistic minorities. Second, submit reports to the President. Third, to monitor implementation of safeguards. Objectives. First, provide equal opportunities for linguistic minorities. Second, spread awareness amongst linguistic minorities. Third, to ensure effective implementation of the safeguards. Fourth, to handle representation for redress of grievances. Comptroller and Auditor General of India is provided under Article 148 of the Indian Constitution. CAG is the head of the Indian Audit and Accounts Department. He is the guardian of public purse and controls financial system of state and center. Appointment and term. He is appointed by President by warrant under his hand. Oath and affirmation is given by the President, under which he bear true faith and allegiance to the Constitution. Second, he uphold sovereignty and integrity. Third, he perform his duties. Fourth, he uphold Constitution and the laws. His tenure is 6 years or up to the age of 65 years. He gives his resignation to the President. CAG can be removed by the President, same as a judge of Supreme Court. Resolution passed by both houses with special majority. Independence of the CAG. First, he is provided security of tenure. He does not hold office during the pleasure of the President. Second, he is not eligible for further office either in Government of India or Government of State. Third, the salary and other service conditions are determined by Parliament. His salary is equal to that of Judge of a Supreme Court. Fourth, neither his salary or rights can be altered. Fifth, powers of CAG prescribed by President. Sixth, expenses charged on Consolidated Fund of India. Duties and powers. Constitution under Article 149 authorizes to Parliament to prescribe duties and powers of CAG. He audits first account of all expenditure from the Consolidated Fund of India, Consolidated Fund of each state and UTs having Legislative Assembly. Second, he audits all expenditure from the Contingency Fund and Public Account of India and each state. 3. He audits all trading, manufacturing, profit and loss accounts, balance sheets and other subsidiary accounts kept by centre and state government. Fourth, he audits receipts and expenditure of centre and each state to ensure assessment, collection and allocation of revenue. He audits receipts and expenditure of A. all bodies and authorities financed from the centre and state revenue. B. government companies. C. other corporations and bodies when so required by the related laws. Sixth, he audits all transactions of central and state government. 7th, he audits all accounts of any other authority when requested by President or Governor. 8th, he advises President with regard to prescription of center and state account. 9th, he submits audit reports of center to President and President places them before Parliament. 10th, he submits audit reports of state to Governor and Governor places them before state legislature. 11th, he ascertains and certifies net proceeds of any tax or duty under Article 279. 12th, he acts as a guide, friend and philosopher of Public Account Committee. Under Article 151 of the Indian Constitution, CAG submits 3 reports to President. The audit report on first, appropriation accounts, second, finance accounts, third, public undertakings. President lays these reports before both houses of Parliament. Public Account Committee examines these reports and reports its finding to Parliament. CAG is an agent of Parliament and conducts audit of expenditure on behalf of Parliament. Hence, he is only responsible to Parliament. Legal and regulatory audit is obligatory, while proprietary audit is discretionary. Constitution of India visualizes CAG to be Comptroller as well as Auditor General. Role of the CAG. In 1968, Audit Board was established to associate outside specialists and experts. It was established on the recommendations of the Administrative Reform Commission. It consists of chairman and 2 other members appointed by CAG. CAG's roles in auditing public corporation falls into 3 categories. First, some corporations are audited totally and directly by CAG. Second, some corporations audited by private professional auditors. They are appointed by central government with the consultation of CAG. Third, some other corporations are totally subject to private audit. They submit reports directly to Parliament. For example, LIC of India, SBI, Food Corporation and others. Criticism of the CAG. First, the function of the CAG in an inheritance from the colonial rule. The CAG is today a primary cause of widespread and paralyzing unwillingness to decide and to act. Third, Parliament has failed to define the functions of the CAG. Fourth, the function of the CAG is not really important. Fifth, auditors know what is auditing, which is not administration. It is a necessary but a highly pedestrian function with a narrow perspective and a very limited usefulness. Sixth, a deputy secretary in the department knows more than the problem in his departments than the CAG and his entire staff. Article 76 of the Indian Constitution provides Office of Attorney General of India. He is the highest law officer. Solicitor General of India and Additional Solicitor General of India assist Attorney General to fill the responsibilities. Article 76 does not mention about Solicitor General and Additional Solicitor General. Appointment and term. He is appointed by President. He must be a person who qualified to be appointed a judge of Supreme Court. In other words, he must be a citizen, he must have been judge of High Court for 5 years or advocate of High Court for 10 years or eminent jurist. His term is not fixed by the Constitution. He holds office during the pleasure of the President. He resigns when the government resigns or replaced. He may quit by submitting resignation to the President. He receives remuneration as President may decide. Duties and functions. As a Chief Law Officer of India, first, advise Government of India. Second, perform other duties assigned to him by the President. 3. Discharge functions confirmed by Constitution or any other law. Duties assigned by President. First, appear in Supreme Court on behalf of Government of India in concerned cases. Second, represent Government of India in Supreme Court when referred by President under Article 143. Third, appear in High Courts in case of concern related to the Government of India. Rights and limitations. Attorney General has right to audience in all courts. He has right to take part in proceedings of both houses of Parliament or their joint sitting and any committee of Parliament of which he may be named a member but without right to vote. He enjoys all privileges and immunities that are available to the member of Parliament. Limitations. First, he should not advise or hold brief against Government of India. Second, he should not advise or hold a brief in cases in which he is called upon to advise or appear for Government of India. Third, he should not defend accused persons in criminal persecutions without permission of Government of India. Fourth, he must not to be director of any company or corporation without permission of Government of India. He is not government servant and not debarred from private legal practice. Article 165 of the Indian Constitution provides Office of Advocate General. He is the highest law officer in state. He corresponds to Attorney General of India. Appointment and term of the Advocate General of State. He is appointed by Governor. He must be a person to be qualified to be Judge of High Court. In other words, he must be citizen. He must have held judicial office for 10 years or he must have been Advocate of High Court for 10 years. Neither term of his office nor procedure and grounds of removal fixed by the Constitution. He holds office during pleasure of Governor. He resigns when state government resigns or replaced. He receives remuneration as Governor may determine. Duties and functions of the Advocate General of State. First, advise to government when referred by Governor. Second, perform his duties. Third, discharge functions conferred by Constitution or any other law. He can appear before any court of law within state. He has right to take part and speak in proceedings of both houses of state legislature or committee of which he may be named a member but without right to vote. He enjoys all privileges and immunities available to member of state legislature. Article 165 Advocate General of State. Article 177 Rights of Advocate General with respect to houses of state legislature or its committee. Article 194 Powers, privileges and immunities of Advocate General.